Hello friends, in the series on income tax cases, today we will discuss a very important case on section 148 and 151. This case has been reported in 448 ITR at page number 1 and the matter has been decided by Honorable Allahabad High Court and the matter has been decided on 8th September 2022. In this particular case, a number of the writ petitions were decided through one common order. A batch was made. The main issue was involved that the assessing officer issued the notice having the signature of the assessing officer, having the digital signature of the assessing officer earlier, and the approval under section 151 having the digital signature of the CIT of the time which was later than the time which was there on section 148 notice. For example, in this particular case, in the case of VIKAS Gupta, the notice under section 148 was having the time at 5:43 and the approval was containing the time at which the digital signature was affixed was 7 and 5 minutes, meaning thereby that the approval was given later on and the notice was issued earlier. So whether this is allowed in law, the court interpreted this whole scenario in a way that notice was issued without taking the approval from the CIT, because the approval which was given after issuing the notice will be totally without application of mind, because the procedure in law is that first of all the assessing officer will make the proposal that it is a fit case for issue of the notice under section 148, then it will present to his senior, then he will apply his mind, and then even in a case when he feels that it is a fit case to issue the notice under section 148, only then the assessing officer can issue the notice under section 148. But in a situation where the notice is bearing the time at 5:43 and the approval is coming 2 hours later, then it gives a message that the notice and the whole process of reassessment was null and void. So in this particular case, the court said that section 282A subsection 1 says that if any notice is issued, then it should be signed. The sign word has not been defined in the Income Tax Act. For definition of the sign or signature, we have to go to the definition of the sign in section 3 clause 56 of the General Clauses Act 1897. For your reference, I am just reading the definition of the signature or the sign which is there in the General Clauses Act. Sign means to sign one's name, to signify assent or adhesion to by signing one's name, to attest by signing, or when a person is unable to write his name, then affixation of mark by such person. The document must be signed or the mark must be affixed in such a way as to make it appear that the person signing it or affixing his mark is the author of the document. The definition makes it very clear that putting the signature or attaching the digital signature is not just a formality. It means that the person who is attaching the digital signature or putting his signature on the paper, it means that he is giving his assent to that document or approval. So all those cases in which the notice was having the time before the time which was there on the approval letter under section 151 were declared as null and void in this writ petition. And the court said that if the department is having the time to issue the notice, then of course the department can do so according to the law. So this case is very helpful. Whenever the assessment has been completed under section 148, then we have to see that what is the time of the digital signature on the notice under section 148 and what is the time of the signature of the CIT on approval under section 151. If the approval has been granted after that, then we can take the help of this case law. At the end of this video, once again, I am repeating the name of the case. The name of the case is VIKAS Gupta versus Union of India and others. And this case has been reported in 448 ITR at page number 1. The matter has been decided on 8 September 2022. Thank you, friends.